Welcome to Immigration Quicktake. This is Ellie Rutledge-Silver with the American Immigration Lawyers Association. This week, the Ninth Circuit Court of Appeals affirmed the Flores Settlement Agreement. Here to share the details is Melissa Crow, Legal Director at the American Immigration Council. Melissa, thanks for joining me. What does this ruling mean for children currently detained who fled to the U.S. accompanied by their mothers?
Ellie, the decision held very clearly that the current conditions in family detention centers are unlawful, and specifically that ICE's family detention standards are inconsistent with the terms of the Flores Settlement Agreement. As most people listening to this quick take probably know, the Flores Settlement was concluded in 1997, and it governs the terms and conditions of release and custody for children in immigration detention. The issue in this case was whether, or one of the issues rather, in this case was whether the settlement applies to both unaccompanied children, which the government conceded, and accompanied children, which the government disputed. And the Ninth Circuit held very clearly that the plain language of the settlement agreement applies to all immigrant children, which is very good news.
Does this decision apply to the detained mothers as well?
The decision is a bit of a mixed bag in that regard. The lower court's decision had held that immigrant children in family detention had a right of release, preferably to a parent, including a parent with whom they were initially detained. Unfortunately, the Ninth Circuit found that parents in family detention don't have an affirmative right of release under the Flores Agreement, but didn't rule out the possibility that parents might be entitled to release on some other basis. In this regard, I think the court really missed the point that the release of the parents is necessary to effectuate the rights of their children. And this was argued by the plaintiffs in the lower court proceedings, but was not addressed by the Ninth Circuit in its decision.
What will happen now?
Ellie, I think this decision leaves the government in a bit of an untenable position. They have a couple of options. They could release the children to other relatives in the United States and continue to hold their mothers, which I think would be a move that would be inconsistent with our nation's values. This decision, under no circumstances, prevents the government from releasing the mothers with their children, either on ankle shackles or some other kind of alternatives to detention, or on notices to appear. So the government has always had the option of putting mothers and children in regular removal proceedings rather than subjecting them to expedited removal as they're currently doing. And I think the third option, which is probably the least optimal, would be to push the mothers and the children through proceedings at an even faster rate than they're doing now. Judge G in the district court found that even children could be held in unlicensed facility for up to about 5 days. So the government could ram the parents and their children through this process in 5 days. And I think the result would be that their due process rights would be violated to an even greater extent than we're seeing. And that simply wouldn't be acceptable. My hope is that the government has the good sense to realize that family separation is not a viable option, and that they don't have the capacity to continue detaining families in a manner that respects their due process rights. Essentially, it's time to end family detention once and for all.
Thanks, Melissa, for joining me. For the rest of you, please stay tuned for more updates from the American Immigration Lawyers Association.